These bills before us today would require medical insurance and welfare coverage for contraceptives. Both of these mandates compel taxpayers to fund contraceptives despite deeply held and religious beliefs they may hold, and for this reason I am a no. Senate Bill 973 is a patent violation of the First Amendment of the United States Constitution and the Religious Freedom Restoration Act of 1993. Why is this a violation? Very simple. By forcing Michiganders to pay for contraceptives through their insurance, despite the fact that it violates the deeply held religious beliefs of many. The latest version of this bill does put in place some caveats, but noticeably missing is a religious exemption. At best, this bill only has religious exemption for those already grandfathered in by the Affordable Care Act. However, this exemption does not exist going forward. In 2014, a similar contraceptive policy was considered by the United States Supreme Court in Burwell v. Hobby Lobby. The court considered whether or not the contraceptive mandate and the proposed religious accommodation were constitutional. The court majority opinion stated, "We must decide in these cases whether the Religious Freedom Restoration Act of 1993 permits the United States Department of Health and Human Services to demand that three closely held corporations provide health insurance coverage for methods of contraception that violate the sincerely held religious beliefs of the company's owners. We hold the regulations that impose this obligation violate the Religious Freedom Restoration Act, which prohibits the federal government from taking any action that substantially burdens the exercise of religion unless that action constitutes the least restrictive means of serving a compelling government interest." When the Affordable Care Act was written, it at least tried to comply with the Religious Freedom Restoration Act of 1993 by building in a process for accommodation for those that objected to the contraceptive mandate. However, the court ruled that this accommodation was insufficient and was not a least restrictive means. In these bills, we see no accommodation going forward, making these bills glaringly unconstitutional. And just to be clear, one would be wrong to think that Michigan would get a pass because the Religious Freedom Restoration Act is a federal law. It clearly applies to both the federal government as well as individual states. These bills are not only poor policy, but will result in the state taxpayer being on the hook to cover millions of dollars in attorney fees and awards. I ask my colleagues to vote no.